Good morning, everybody. Welcome to the presentation on the eviction moratorium. I hope you can all hear me okay and that you're all safe in this smoky weather right now. My name is Justine Gonzalez-Burke, and I work as the Network Weaver for Housing Solutions Network here in Jefferson County. Today's presentation is a collaboration between Clallam Jefferson County Pro Bono lawyers, the Northwest Justice Project, and Housing Solutions Network. Housing Solutions Network is a network of mostly volunteer working groups who are all working on different affordable housing issues in Jefferson County. One of those groups is hoping to provide more resources to tenants and hear from tenants in Jefferson County. So if you're a tenant and you live here and you're interested in getting involved with our organization, please reach out to us. We're really interested in connecting with you all who are listening to this presentation today. You can learn more about Housing Solutions Network at housingsolutionsnetwork.org. We're really excited to be collaborating with Clallam Jefferson County's Pro Bono lawyers for today's presentation. Clallam Jefferson County's Pro Bono lawyers is a volunteer lawyer program serving clients in both Clallam and Jefferson counties. They facilitate legal aid for low-income community members through connecting them with volunteer attorneys. And there are going to be some volunteer attorneys available after this presentation for those of you who might have specific legal questions around your situation. If you're trying to access that legal aid, you can reach out to the Clallam Jefferson County Pro Bono lawyers, and they will be taking calls as they're able to after this presentation. You can learn more about their work at cjcpbl.org. cjcpbl. So a few notes about today's presentation. We are recording the presenters of the presentation, so that will be available on both the Housing Solutions Network and the Clallam Jefferson Pro Bono Lawyers websites after the presentation. We'll try to send out an email to everybody who registered when that link is live. But if you don't get an email, please do check the website if you need to refresh yourself on any of the information, or if you know other people who weren't able to make it today and would like to know, what was spoken about. You can ask questions throughout the presentation through the Q&A chat box at the bottom of the screen, and only the panelists will be able to see your questions. So those will be private, and the panelists are myself and Steve Robbins, our presenter. So just so you know, we won't be able to answer those questions in the Q&A box, or else they will become public questions. So I will be, collecting questions throughout the presentation and asking our presenter to answer them verbally. And so we won't be responding in the chat box. Some of the questions also might not get answered if they're too unique to a specific individual's situation, and those would be best dealt with in a consultation after this presentation. And again, there will be information about how to contact the Clallam Jefferson County Pro Bono Lawyers group, and then they can connect you with a volunteer attorney as they're able to. So I'm going to introduce our speaker, and then we'll get going. Steve Robbins has been the managing attorney for the Northwest Justice Project's Port Angeles office since 2005. Steve has also served on the board for the Clallam Jefferson Pro Bono Lawyers, and we're really excited to hear what he has to say today. So I'm going to hand it over to Steve. Thank you all so much for being here.
Okay, thanks a lot, Justine. My name is Steve Robbins. I'm a legal aid attorney in Port Angeles, and I do a fair amount of litigation on housing. I certainly realize how important this is for everybody out there. Loss of housing and leading to homelessness is, life-changing events. So I hope by this presentation I can help alleviate or help explain some of the aspects of landlord-tenant law, the two moratoriums, state and federal, answer any questions, and go from there. So let me say real quickly who NJP is. We're a civil legal services. We're funded by the government. There's no charge for our services, and the cases that we accept, we take for full case representation. The way you can access us is through the Clear line. I'll give you that number, and it'll be shown eventually on the slides. The Clear number is 201-1014. I really appreciate the help of Housing Solutions and BLP in putting this on. I love doing litigation stuff, but it's really important to do community engagement. Renters have a fair amount of rights under Washington law, and if you properly assert them, you can hopefully maintain your tenancy. Justine, can we put on the slides at this point? We can skip this one, that's me. Can we go to the next screen? Okay, so I'm going to give a lot of information, but there's a great resource, WashingtonLawHelp.org. You can see it on the screen here. You go to their website, click the COVID legal information, and they'll have a lot of information about a lot of different topics, evictions, how to assert yourself, and how to deal with COVID-19 issues. Can you show me the next slide? So you go to the website, there's a drop-down box. You want to hit housing and eviction, as you can see there, and hit that, and there'll be a drop-down box of specific topics in which you can access, print out, and get the information. Okay, next slide. Yeah, I'll get into these step by step, but the one thing I want you to remember in all this is you have legal options. I'll explain the moratorium, I'll explain the rental landlord-tenant law in Washington State, but again, the whole point of this is to make sure everybody out there and anybody can tell that COVID-19 has caused a lot of disruption, and there is help out there. Next solution, next slide. I'll get into these questions at the end. So let me go to my presentation. So I'm going to get into the details of the moratorium and landlord-tenant law, but if you walk away with one thing from anything I say today, it's this: there can be no evictions without court process. Court process means proper notice from the landlord or the property manager. The notice has to be statutorily correct, has to be served upon you in a correct way, and you will always have the opportunity to respond to the petition, the eviction case. You have a right to respond in court and have your case decided by a judge or commissioner. Any other attempt by a landlord or property management company to evict you is illegal. Constructive eviction can be a lot of things, but generally it's when the landlord uses extrajudicial means to get someone out without following the law. That means changing the locks, not providing utility services. It can be a whole range of things, but whatever they are, they're illegal under Washington law, and you have a civil action in court against the landlord or the property management company. Let me first talk just very basic landlord-tenant law that I'm sure most of you know, but we need to know the terms that we're speaking with. The relationship is between a landlord and a tenant or property management company. It's lease. It's best to have a written lease, but there can also be oral leases. There can also be a month-to-month tenancy in which you simply pay rent for a month and you're automatically renewed each month. A lease can be for a specific period of time or a yearly lease. A lease can be month-to-month, depending on the negotiations between the landlord and the tenant. And let me stop here. If anybody has any questions, and Justine, let me know. I'll try to answer them as I go on. So for evictions, there has to be a violation of the lease terms. The lease terms can be regulations from the management company. They can be standard lease terms like don't disturb the quiet enjoyment of your neighbors. it can be a whole range of things. It also can be expiration of the lease term. That means your term is up, the landlord wants you out, and that's the lease term eviction. The way the process begins by proper notice, properly drafted, meeting statutory requirements. It has to be served upon you in a proper way, which usually means service by a sheriff or law enforcement agency. If that doesn't work, the landlord at this point does have other opportunities to serve you, which I'll get into later in the presentation. Once that notice is served upon you, it's vital and really important for you to contact NJP, VLP, Clear, Housing Solutions, contact somebody, because the clock starts ticking once you get that notice. The earlier NJP or VLP can get involved in the case, the better chances you have at successfully defending your tenancy. So after you get the notice, and the notice will be a termination of the lease, or you violated XYZ regulations, the next thing that happens is that you get served a petition, a summons and a petition. A summons is a notice from the court that a petition of eviction has been filed against you, tells you how to respond and when the first hearing is. In the way the process works is after you get served the petition, the request for an eviction, you have the opportunity to do two things. Before the show cause date, show cause is your landlord's opportunity to present the case to the commissioner or the judge. Before that date's set, it's usually on a Friday, before that date's set, you have the opportunity to file a declaration. A declaration is a statement that you make under oath saying to the commissioner or to the judge what your side of the case is. You can also file an answer. An answer is a response to the petition filed by the landlord or the landlord's attorney. In the response, you either agree or disagree with what they're saying against you. When you go to the show cause hearing, even if you haven't submitted a written declaration prior to the show cause hearing, under Washington law, you have the full opportunity to present both a legal and equitable defense at the show cause hearing. A legal defense would be improper notice, or it wasn't properly served, or other defects. If that's correct, then the court does not have jurisdiction to hear the case, and the case will be dismissed. Or you can respond with equitable arguments that it's not fair to evict you, that considering all the circumstances, the eviction shouldn't go. At the show cause hearing, the decider, the judge or the commissioner, will decide one thing. Is there a sufficient factual or legal argument made by the tenant to require a full hearing? If a full hearing is required because there's disputed facts or disputed law, it'll be held by that same judge or court within 30 days usually. It's a summary proceeding. What a summary proceeding means is that under Washington law, usually cases take a fair amount of time to resolve themselves. A family law case, a divorce, commercial cases. Landlord-tenant law is different. It's meant to be quick, summary. So after the show cause hearing, there'll be a hearing set in which it's a full hearing. You have witnesses, you make your legal arguments, hopefully represented by an attorney, and the judge at that time will make a decision whether to grant the petition or to deny it. If it's denied, then that's obvious, the case is dismissed. If the judge agrees with the landlord and agrees that there's a basis for the eviction, what happens next is that the landlord seeks and gets a writ of restitution. That's just a fairly fancy term for an order from the court to go to the tenant to tell them they have to vacate the property. If they fail to vacate the property, the sheriff can take additional steps to make you leave.
Steve?
Yes.
Can I jump in here? Because we have a couple of questions
please,
that I'd love to ask you.
Yes.
So the first one is, how do you prove a verbal lease?
A variety of ways. Either you have witnesses or it can, it often, I do a fair amount of these. It can often come down to one person saying A and one person saying B. So if you have an oral lease, it's good to try to document it, send a confirming letter to the landlord saying we agreed upon this and this and this. And if you can't do that, you have to prove in court that what the landlord's saying isn't what you agreed to, and that's difficult. I don't want to get too much into legal things here, but when you go to court, the obligation, the responsibility is on the landlord to prove their case. But the level of evidence is kind of low. In the criminal cases, I'm sure most of you know, you have to prove guilt beyond a reasonable doubt. In this kind of case, in a civil case, all the landlord has to do is prove by a preponderance of evidence. That means it's more likely than not that what they're saying is correct, and the person is subject to eviction. So if you have an oral lease, your first step should be to try and get a written lease, because that way the court knows exactly what was agreed to. If you can't get a written lease, document contemporaneously, at the same time, the payment of rent, any agreements that you think you and the landlord agreed to, date it and keep a copy of it to present to the court at a later date. But my best advice for oral leases is at all possible to try and get a written document laying out what you and the landlord agreed to.
Great, thank you. And so what part of what you're saying is you can show the payments that have been made as part of that?
Well, actually, more if the payments, making monthly payments, lease or no lease, is a automatic renewal of a monthly tenancy. Further, accepting monthly payments or accepting rent payments does give the tenant the opportunity to argue to the trier of fact, the judge, that the landlord accepted money, knew of any possible violations of a oral lease, but kept accepting the money, and you can argue a waiver of the violations of the lease.
Okay, we have a couple of other questions. So
Sure.
the second one is, what about eviction for lack of payment from a tenant who had not been adversely affected financially by the pandemic?
Yeah, that's the moratorium question, and it's a good question. And what that means is the state. There's two moratoriums, state and federal. Let me talk about the state one because that's the one that is best for Washington State. The governor's moratorium specifically said if you're in that enviable position of COVID-19 not affecting you, not affecting your income, not affecting your hours, nothing like that, you have a responsibility, obviously, of continuing to make rental payments. The moratoriums only apply to people who are affected directly by COVID-19. So if you're not affected by COVID-19, there's still a responsibility to pay rent.
Great. And the last question is, can a no-cause eviction still happen?
Again, I'll get into this in the moratorium, but under the Washington moratorium, there's basically non-payment of rent is not a basis for eviction. What is a basis for eviction, and it's pretty limited, is a statement, a declaration, an affidavit from the landlord saying they intend to move back into the premises or sell the premises. And it has to be a 60-day notice, so you have enough time to vacate. And in those conditions, there is a basis for eviction. But if it's a non-payment of rent case and the renter has a legitimate COVID-19 problem, then it's very unlikely that there's an eviction action. And I should try to say at this point, it's probably a good thing to everybody to remember, the moratoriums are a Band-Aid. The rent's still going to be owed at either the end of the state or the federal moratorium. The landlords are in a terrible position because many of them are seniors, low income, and are relying upon rental income for their livelihood. So the moratorium is great to stop evictions, but the problem is what's going to happen next. And I don't want to get into political things. We have no idea what's going to happen next. Or the landlord's going to be compensated, or the tenant's going to get rental assistance. that's all kind of up in the air until further political action is taken by the government.
Thank you for answering those questions. So if you have questions, you can put them in the Q&A box down below, just for those folks who joined since we got started, and you can keep going with the presentation, Steve.
Okay. One last thing, at the show cause hearing, or at that trial, actually at the full trial, you can present to the judge set-offs. Set-offs are typically, my rent was $400, the landlord cut off my water for a month, I shouldn't have to pay the full $400 for a rental that had no water. But that's about, when you go to court, you can either say, don't evict me, or have a set-off. And again, a housing action is meant to be summary, quick, so you have to respond quickly and make your arguments. After the trial, if you lose, or if you win, you win. If you lose, the sheriff will issue the writ. You'll have to vacate by a certain date. There is some room to negotiate, but not very much. And then after you vacate the premises, it's really important. Eviction action is a two-step process. The first hearing, or the first part of it, is who's entitled to possession. Is the landlord entitled to possession? If the trier of fact decides, yes, they're entitled to possession, then the person has to vacate, and there's a second issue of damages, which is be held at a second hearing, in which the landlord can say, I'm owed $1,000 rent, and they broke 2 windows for $50. At that second hearing, you have the opportunity to deny that, say, I did pay rent, or I didn't break the windows. But if you don't keep in touch with the court with your new address, you won't get notice of the second damages hearing, and it's likely, very likely, that the landlord will get any damages that they allege to the trier of fact. Okay, before I go to the moratorium, are there any other questions?
Yes, in fact, there is.
Okay.
Question, do you have to show cause? Sorry, do you have a show cause hearing if the landlord is trying to do a no cause eviction?
Any eviction, any type of eviction, whatever you call it, has to go through court. There's no, unless it's a constructive eviction, which is illegal. So it has to go through court.
So is that a yes?
Yes.
You have to have
a no cause eviction, I think we might not be talking about the same terms. No cause eviction is really kind of a thing that doesn't really affect most people in this situation. Again, you can't be evicted for non-payment of rent under most circumstances. And the only way you can be evicted under Washington's moratorium, which I'll get to in a minute, is on those 2 very specific, they're going to sell the property, or the landlord intends to move back, and there's a 60-day notice.
Okay, last question on this area was, if I was given an ultimatum to pay or vacate, told the landlord I was intending to pay and catch up.
Yep. Again, that would be clearly within the moratorium. If you make, now you should pay whatever you can for rent. I'm not saying you shouldn't, but if you can't afford to pay rent and you say to the landlord, I'll pay you next month, and you're not able to pay next month, that's still, if they go ahead with the eviction for non-payment of rent, which under the state and federal moratoriums are prohibited. So even though you make that commitment, it's not legally binding at this point.
Great. And Cherish Cromner from OLICAP would like to remind everybody that OLICAP does still have funds to help folks with rent if they've been affected by COVID-19 and meet state criteria. So visit olicap.org to get assistance with rent payments, and you can move on now.
Yeah, and at the end of my presentation, I'm going to give a couple of numbers in addition to OLICAP for tenants to contact to try and get assistance. Okay, so the moratorium. It's important to put the moratorium in context. The moratorium, as I said before, is not a solution. The moratorium does stop people from getting evicted for the very reasonable basis that if you get evicted at this point, you're very likely going to be homeless, which is a spiraling downward effect on the renter and the family. The money, the rent's still going to be due. The only solution to this is going to be a political solution. Both the renters and the landlords have very legitimate expectations. And the only way those expectations are going to be met realistically is by some kind of assistance. So, as I said, there's two moratoriums. There's both a state and federal. I'm first going to talk about the state moratorium. It's more extensive than the federal moratorium, and I think it's the one that we're going to mainly be dealing with in the future. Right now, the state has extended the moratorium, Governor Inslee, to October 15th, 2020. Obviously, we don't know at this point if it's going to be renewed or not. My strong intuition is that it will be renewed for a substantial period of time. So what the state moratorium does, first, as I said before, there has to be a relationship between COVID-19 pandemic and loss of income, loss of hours, any negative impact upon income is legitimate. But if you're in that enviable position of having COVID-19 not affect you, then the moratorium does not apply to non-payment of rent, and you're still unfortunately are going to not have a problem in showing a relationship between COVID-19 and loss of income and loss of hours and dire effects from the moratorium.
Steve,
So,
I'm sorry, you cut out for a second. Would you mind going back a couple sentences and just repeating that?
sure. So there has to be a relationship between the virus and loss of income. If there's not a relationship between loss of income, loss of hours, and the virus, then you're still obligated to pay rent to the landlord. And the moratorium simply won't affect the rental payments. As I said, I think most people out there are affected by COVID-19, have a loss of income, and the moratorium will apply to you. So the reason why the moratorium is important is that on May 29th, the government ordered courts to be open for non-emergency civil actions, which obviously would include evictions. But Governor Inslee realized that that would cause a swamping of the courts with eviction cases. So the state government extended the moratorium, at least now, to October 15th. The moratorium applies to leases, no leases, long-term care, transient housing, mobile homes, RVs, almost any rental arrangement is covered by the moratorium. So the moratorium says landlords, property owners, or management companies are prohibited, not allowed, from serving or enforcing any notice to vacate. Now, there's a whole lot of notices, but the main ones that we would be concerned with would be pay or vacate, comply or vacate, or lease termination. Those are all covered by the moratorium. And now here's the two exceptions. If the landlord or property owner files an affidavit of necessity, that means a sworn statement to the court that due to the immediate risk to health, safety, or property of others caused by the tenant, they should be evicted. This is going to be it's the one area of the moratorium that allows the landlord to at least allege that the tenant is causing serious problems at the leased premises, and it's vital for the health, safety of other tenants for the person to be evicted. So that the moratorium does not stop that. And if you're in that situation, you're still facing eviction. If the landlord can prove that in court, that you're an actual threat to safety and quiet enjoyment of your neighbors. And the only other exception is a 60-day written notice to the tenant that the landlord intends to personally occupy the premises or sell the premises. Other aspects of the state moratorium. Service. Sheriff's police are prohibited from serving eviction notices at this time. Fees. Landlords are prohibited from assessing or threatening to assess late rental fees. Collection of past debts is prohibited unless the landlord can show by a preponderance of the evidence, which means it's more likely than not that a plan was offered based upon the individual financial situation and the tenant still refused to pay. Rent can't be increased during this period, and no retaliation. So the state moratorium, as opposed to the federal moratorium, is more extensive. It's in effect as of now, and it's the one that would probably, will very likely affect everybody in this chat. But does anybody have any questions about the state moratorium?
Well, there are a couple of questions.
Okay. Sure.
Yes, and I think most of them respond to the state.
Okay.
The first one is, can a landlord evict a month-to-month tenant to move in a family member if the tenant doesn't leave in 60 days?
Well, there's two things there. The 60 days, that's when the landlord, by proper notice, gives notice to the tenant that they're coming back to live in the premises or they intend to sell the place. So if the landlord, if after the 60 days they don't move in, that still wouldn't be a defense to the eviction action. The landlord would file a petition saying, I gave the renter notice that I wanted to sell or occupy the premises. Here's the notice, properly served. And the court at that point would very likely order the writ of restitution. So the answer is that doesn't make much difference.
And so maybe part of the question is, does moving a family member in count as the landlord wanting to move in?
Obviously, that hasn't been litigated. And I'm an advocate for tenants, that would be a difficult argument to make, that it was a family member, not the actual landlord that moved in. But it could be made. And you never know how a court's going to go with that. But again, I think it's a dubious legal strategy. But possible.
Okay.
Yeah.
Second question, can rent and utilities, the charge for rent and utilities, be raised under the moratorium?
No.
Okay. Does the moratorium apply when a family has a special expense due to COVID-19, not just a reduction in income?
Yes. Yeah. The moratorium, the loss of income is one thing for sure. Loss of hours would be another situation. Or if you can show extraordinary medical expenses due to COVID. So that would absolutely be a legitimate argument under the state moratorium.
Great. So under the rent freeze, if a tenant is not affected by COVID-19, is the landlord still required to, leave the rent frozen?
I'm sorry, what was the last part of that question?
Even though I haven't been impacted by COVID-19, is my landlord required to not raise my rent?
No. Now, raising the rent, I'll get into this at the end of my presentation, but that's governed by Washington law. There has to be proper notice. But if the landlord gives you proper notice of a rent increase and you're not affected by COVID-19, then that's legitimate.
Okay.
Okay.
One more question is slander of character in the community seen as retaliation?
I get this question a lot, and I got to explain the legal aspects of it. Slander is a really specific legal action that's complicated, hard to prove, and very likely not going to be deemed by a court, by a judge, as to be retaliation. Retaliation is like you don't have any water and you make a complaint to the public health agency and you document it. And then after the public health agency contacts the landlord, he or she tries to evict you. That's retaliation. If the landlord or somebody associated with the landlord is saying bad things about you, and even if you can prove it, that would be a legal stretch to call that retaliation.
Okay, those are all the questions for now. Oh, sorry, one more.
Okay, sure.
Even if you have a reduction in earnings, what happens if you get the unemployment benefit and special compensation? Does that still fall under the moratorium?
Special compensation, I'm not quite sure what that means.
I guess the question is asking if somebody has had a reduction in earnings, a tenant presumably, but has made up for their loss of income in other ways, including unemployment benefits, are they still protected from eviction under the moratorium?
Likely, not for sure, but likely. The landlord would have to affirmatively make a complicated legal petition to the court saying, okay, they lost money to COVID, but now they're getting unemployment so they can afford. That would be hard to see how that's going to go. But again, a lot of this, and I need to emphasize this through the whole presentation, a lot of this obviously has not been litigated. There's been a moratorium. I've litigated a few cases, both based upon the 60-day I want to move back in and the threat to the health and safety of other tenants. Those are pretty limited exceptions to the moratorium. And a lot of these questions, for better or for worse, can't be answered until the judge or an appellate court makes decisions. But one thing I would emphasize to everybody out there listening, these are all legitimate litigation issues. The litigation issues are things that can be presented to the judge and make you want done. And that's our role here, representing tenants in legal actions. And I litigate a fair amount of cases. Okay, any more questions, Justine?
Yes,
Okay.
It looks like there's one more. Can an eviction be legal when it is given as a social retaliation? In other words, a disagreement between landlord and tenant.
Depending on what the disagreement is, if it's a personality conflict, very likely not. If it's a worse kind of disagreement, physical altercation or something like that, then it wouldn't be the social thing. It'd be, violating somebody else's quiet enjoyment. So generally, no. Generally, you could not be evicted on spurious grounds.
Okay, it sounds like somebody's still a little bit confused about if moving in a family member is a litigation issue that you, Steve, would see is worth pursuing.
That's a really good question. Again, I'm here as an advocate for tenants. I couldn't guarantee that we would take the case. I would strongly consider it to see if that's really what the moratorium is about. Is it about the owner coming back in, any family member coming back in? But I could see the argument on the landlord side saying, okay, you let me sell the property. Why can't I have my sister move in until I sell the property? So that's hard to answer without any case law that I can rely upon.
Okay, thanks. I think you can move on for now.
Okay. So the state moratorium, it's a really good moratorium and it's working so far. There's a federal moratorium now. On September 1st, the federal Center for Disease Control issued a nationwide eviction moratorium starting September 4th, running through December 31st, 2020. Now, there are issues with the legal issues with this, whether it's constitutional or not. Obviously hasn't been litigated. I get housing notices and it's already, there's already threats to litigate the cases being beyond the constitutional authority of the CDC. Now, that's not for us to decide. That is for courts to decide. Right now, if the state moratorium expires on October 15th, you're still protected. You're still protected by the federal moratorium. It does not override state protection. So as long as the state moratorium is in effect, we'll use that. If that expires, which I doubt, but if it expires, then we move to the federal moratorium, which is expansive, which is a lot. It covers all rental property. No tenants can be evicted for a non-payment of rent if, and this is the big if, the tenants have submitted a declaration. A declaration is a statement made under oath that what you're saying is true, explaining income loss, loss of hours, or significant medical expense. So what you have to show in your affidavit declaration, and if anybody needs copies of blank declaration, I can send one to both Justine and to Shauna, so you can access it that way, or you can contact NJP. So you first have to submit the declaration showing that because of COVID, there's been a loss of income or substantial extraordinary medical expenses. Next, you have to show in the declaration and statement by statement that you have made your best efforts to try and obtain government assistance. The next thing you have to show is your income. And these are really high income levels. If you're a single person and you earn less than $99,000, you're eligible. If you file a joint return and make less than $198,000, you're eligible. You're also eligible if you received a stimulus check, and you're also eligible if you did not file a 2019 tax return. In the next part of the declaration, you have to say you're unable to pay the full rent due to loss of income, hours of work, or extraordinary medical expenses. You have to say in the declaration that you're making your best efforts to make timely partial payments as close to the full payment as possible. You also state that if you're evicted, you would likely become homeless. And finally, you have to say that you understand that ultimately the rent's going to be owed. You make this under oath that you're telling the truth. You submit a copy to the landlord, date it, keep a copy, and that is the declaration. Who has to sign the declaration? It has to be the tenant, obviously, and any adults in the household, showing that they're also eligible. Date it, keep a copy, and go from there. Now, you don't have to have documentation, but if you have documentation, it's extremely helpful. It will enable, if necessary, when you go to court, to show the court that, yeah, you have no income or very limited income. If after you submit the declaration to the landlord, and the landlord still proceeds with the eviction under the federal moratorium, it would be really important at that point, again, to contact BLP, Clear, NJP, Housing Solutions, in order to litigate, to go to court to stop that. And under the federal moratorium, there's actually significant consequences for a landlord who violates it. They can be fined up to, how much is it? $100,000 civil fines, and they would also face a year in jail for criminal violations. So it's real serious. So my advice at this point would be, if you can make partial payments, make them, keep a copy, or you get a copy of the receipt, or make a copy by a check or whatever you do to prove it. And make sure the landlord knows of your situation. The best way to do that is not verbally, but through a declaration. So just real quickly, let me give two numbers here for mortgage assistance and emergency rental assistance. I'm sure people out there know more than I do about this aspect. For mortgage assistance, the number is 1-877-74-64-334. For emergency rental assistance, 211 or the 211 website. And for Clear, which is the NJP contact, it's 201-1014. Okay, so I'm going to go now to some recent changes in landlord tenant law, but before I do that, does anybody have any questions?
Yes, thank you for letting me jump in. We've got a couple questions.
Sure.
So talking about the federal moratorium, it was recently ruled that the state moratorium does cover the folks who are unhoused and who are camping at the fairgrounds.
Yep.
And the question is, does the federal moratorium also cover their situation?
Again, that hasn't been litigated, but it's a very, very broad moratorium. As an advocate, I would say it does. But again, that hasn't been litigated, hasn't been going to court.
I see. Next question is there a form for the federal affidavit?
Yes, not a, it's not a legal form. It's a suggested declaration from housing law advocates and national housing law advocates. And it's simply a declaration which details what I said about the moratorium, in line by line. Again, if anybody needs a copy of that, I'll contact Shauna and Justine, get them a copy, or contact me if you need a copy. But it's very straightforward.
Okay. Another question for the federal moratorium is, if a tenant can pay rent, can they still be evicted under the federal moratorium?
Well, they could be evicted if they're paying rent. Then they obviously can't be evicted for non-payment of rent, but they can still be evicted for violation of lease or termination of lease, or if you're paying rent, then the moratorium doesn't really apply.
Okay. Another question is, do you keep your documentation supporting the declaration to yourself and with your advocate, and not share documentation with the landlord for security or privacy reasons?
Yeah. You don't have to, the federal requirement does not require documentation. The documentation I was speaking more of, if it goes to court and we're representing you, it would be great to show to the judge documentation, properly redacted of your income or lack of income. But no, you don't have to give a copy to the landlord. You're declaring under penalty of perjury, under oath, that what you're saying is true, and the landlord, if they don't accept it, they can litigate it, but that would be extremely unusual.
Okay. Another question is, where does one find the penalties for the landlord?
That's in the federal moratorium, the exact sites. Well, I think I can probably give it to you if anybody really cares. I don't have it, but it's in the Federal Register if you really need to see it. But it's there.
So I just wanted to clarify something. Can you clarify, Steve, whether or how the moratorium prevents all evictions for lack of payment, or just people who are affected by COVID?
Just people affected by COVID. That's the clear intent of both the state and federal moratoriums. It's meant to be a temporary bridge between people losing their income and not losing their housing. But if COVID has not affected you, fortunately, you're in the same position as when COVID wasn't here.
So if you're paying your rent and following lease agreements, you can't be evicted. Is that it? But that's a question.
Yeah, well, yeah, except for like lease termination. Your lease term gets end at October 1st, then you would be subject to lease termination proceedings.
Okay, so this question is a little bit unrelated to the moratorium, but still interesting to know given the political climate. Can a landlord ban the display of political signs by a tenant? And if such a rule is a violation, and if such a rule is violated by the tenant, is that cause for eviction?
That would be an extremely difficult case to argue on the landlord side. The landlord would have to show that posting a sign for Trump or Biden somehow affects the health, safety, and welfare of other tenants and is unacceptable. Again, that would be extremely unlikely. And, I'm sure we all know about the First Amendment, right to speak your piece. That would be a portion of that. So I don't see how a landlord could evict for non-controversial political signs. Now, the political signs controversial, again, I think it'd be hard to show a relationship between that and any threat to health and safety of tenants. So that's extremely unlikely.
Great. So I just want to reiterate for folks that at the end of the presentation, we are going to say all of those phone numbers and have information on the screen for how you can access these resources. So just so you know, that will be given again if you didn't catch those phone numbers that Steve wrote down. And Steve, I just want to, as myself as a layperson who doesn't, understand legal things, what I'm basically hearing in what you're saying is that the government, state and federal, have put out these moratoriums, but the exact legal case by case situation, since those haven't been argued in courts of law yet, or are just beginning to be, a lot of these really specific questions don't have a precedent, and so there's not a direct answer. Is that correct?
That's correct. And like what somebody raised a question, can the landlord use a family member to say, I'm moving a family member in? Those are the kind of issues that will have to be very likely litigated. It's a nationwide thing, so there's bound to be cases involving that. But again, this is a whole new area, and I can give my thoughts until the judge makes a decision. It's up to him or her to decide if I'm right or wrong. So yes, it hasn't been litigated, but on the other hand, I think both the state and federal moratoriums are fairly clear and specific and enforceable. And I saw a question about the federal moratorium. It expires December 31st, 2020.
All right, thanks. That was all the questions for now.
Okay, so just let me end this with some discussion of substantive Washington landlord-tenant law. For anybody that cares, you can find this at RC Revised Code of Washington 59.12. So the changes that the legislature has made and RA are in effect. Rent. The previous law was if you were behind in rent for 3 days, the landlord could give you a notice, either pay or vacate within 3 days. That's been changed to 14 days. It was changed in order to give the tenant more opportunity to get the money together to avoid an eviction. If it's not paid in 14 days, the landlord may file. The legislature also ordered that there's no late fees until 5 days have passed. If there is an eviction under current Washington law, it's for rent only, not for other charges. Utility hookups or trash collection or anything like that. It's rent only. An important aspect of the new law is landlords are now obligated, required to accept pledges from rental assistance programs. Previously, a landlord had the option of saying, no, I don't want rent from this agency. Now they have to accept it, either partial or full payment. And they don't have the option of saying, no, I'm not going to take rental assistance from XYZ agency. And finally, there's kind of a technical thing, but it's how you get notice of the eviction. The way the law used to be is that if you couldn't serve a tenant, you would have to go back to the judge and say, I can't serve them, let me serve it by posting. Posting means taping on your door or your front gate. The law has changed and said if the landlord can show, quote, due diligence, end quote, which means 3 diligent attempts over 2 days to serve the person, but they were unsuccessful, then the landlord or the property management company can serve by posting, taping it. So let me conclude with this. Everybody out there has the right to litigate their cases, and it's really important that you contact some kind of agency, legal agency, to access the courts. I'm sure you all know that if you do face an eviction, it's life-changing. It's hard to get new rental agreements. And if you have a legitimate argument, it's important to make it to the judge. So if you can pay, keep receipts. If not, make partial payments and keep track of it. And finally, upon service of notice, don't wait to contact the LP, Housing Solutions, or NJP. Do it as soon as possible. Okay, that's my presentation.
Thank you so much, Steve. This was really, really informative. So we have still 15 more minutes scheduled for this if other folks have questions, and maybe we can go back to that screen that has all the information for how to contact Clallam Jefferson Pro Bono Lawyers, Northwest Justice Project, all of those. So if we can get that screen up, just for for listeners to know, you know, Clallam Jefferson Pro Bono Lawyers is an association of different volunteer attorneys. So they're going to be ready after this presentation to field as many calls and emails as possible. If anybody has, you know, wants to try to access these legal resources, and they'll have to wait for you to contact them. So reach out. You see the phone numbers on the screen, and you can also email that email address. And it says here the intake lines will be open until 1 o'clock. If you're unable to get through, please leave a voicemail or email the email address, and they will get back to you. They'll arrange for a consultation. And with that, are there any other questions that folks have? Okay, we got a couple coming in. What is the proper service of eviction during this time?
Okay. The proper service in those very limited situations, right? Either a threat to the health and safety of others, or the landlord intends to sell and move back in, that would be done in the regular service process by the sheriff or the police.
Okay, another question. Do you have thoughts on things county commissioners could do to prevent displacement? It does seem like financial assistance is most important because in the end rent will be due, but are there other things?
Realistically, I don't think so. This isn't a local and state problem. It's a national problem. And national associations for landlords make the very cogent, legitimate argument that many of them are small business people. They're going without rental income, and it's devastating. Just as it's devastating to people who lose their jobs because of COVID, this is equally devastating for small business landowners. It's a very difficult conversation to have without some kind of political will to solve it. It is going to take, the only way I can characterize it's going to take a lot of money for both sides to satisfy the actual issue of rent and payments to the landlords.
Okay, can non-payment of rent as allowed under the moratorium ever be used negatively on a tenant's credit rating?
Again, that has not been litigated. It's a real interesting legal question. I don't know the answer to that.
Okay. Another question is receiving unemployment, maxing out a credit card, and taking out a loan still seen as having enough money, quote unquote?
That would, again, I hate to keep saying that's something that would have to be litigated. On one side, the landlord's going to be saying they have more than enough money to pay. On the other hand, the tenant's going to show what their expenses are. So a lot of it is very individually driven and depending upon the specific facts of that particular case. So it's hard to give a yes or no answer.
Okay. Another question sounds like coming from a landlord is, at the end of a lease, can we give notice of non-renewal and expect the non-COVID affected tenant to vacate without violating the moratorium?
Non-COVID affected tenants are not covered by the moratorium and would still be subject to the regular eviction process in Washington.
Okay, this is a I'm not sure how related this question is, but maybe it is related. If you find out that the zoning for the property you are on is illegal, what rights do you still have?
If the what on the property is illegal,
If the zoning for the property.
uh, that would not really be a landlord-tenant issue. That would be more of a civil action uh, brought against the owner or the property management company of that particular property. But that's not really a landlord-tenant issue.
I see. And one last question is, does the service of an eviction notice have to be done by a law enforcement officer?
No, it can be by a private service company.
Okay, we still have some more minutes for questions. That's all of them for now. I don't know if that brought up any thoughts from you, Steve. And as folks can see, the phone numbers and the email address are still here on the screen for you to write down. Also, contacting the Attorney General hotline if there are questions about the state moratorium is a good option. That could be found on the website, on the state Attorney General website. We're going to have the recording of this session up on the Housing Solutions Network website and on the Clallam Jefferson County Pro Bono Lawyers website. And again, those are housingsolutionsnetwork.org and cjcpbl.org. And I'm going to put those in the chat box since we don't have them up on the screen there. So you can look to the chat box for both of those website addresses. Learn more about both organizations just in general there as well. We have another question coming up, Steve. Is Washington considering extending the state moratorium?
Let me give you my opinion about that, which means nothing. I believe, Governor Inslee has been very proactive in this particular area. The current moratorium expires October 15th. I would be surprised if it's not extended. But again, that's a purely political decision by the government, by Governor Inslee. Again, I just think it is going to be extended. But if it's not, we still have the federal moratorium to rely upon.
So we have a question back. Since there aren't any other questions, I'll go with this one, although it's not quite related to the moratorium. With
Sure.
the zoning issue that was mentioned earlier, what does it mean that it's a civil issue? How is that litigated?
Civil issue, you would bring whoever the aggrieved party is, would file a petition in Superior Court alleging that the zoning for whatever the issue is about the zoning is illegal or doesn't follow requirements, whatever it might be. But it would only be done by a petition to a Superior Court. That's a civil case.
Great. We have some time for more questions, but I'll just say I have really appreciated the Clallam Jefferson County Pro Bono Lawyers organization and Northwest Justice Project with Steve Robbins, coming to do this presentation today. That's obviously been such a, there are a lot of questions about this eviction moratorium, and it's really helpful. And I hope that you all who've attended today can direct anybody that you know who needs these services back to the websites to watch the recording of this, or to the Clallam Jefferson County Pro Bono Lawyers website to get those resources. And we have another question, which is, are you currently receiving requests for legal services because evictions are being attempted, or are you anticipating a tsunami of legal, assistance requests?
Both. I've gone to court over COVID-19 evictions already a few times in Clallam, and I have one pending in Jefferson. But yes, I don't know. I don't know if there's going to be a tsunami of evictions after the moratoriums are lifted. I just don't know. I think a lot of that is going to depend on if there's some kind of relief for both tenants and landlords. If there's not, it's going to be a mess.
Yeah, maybe you could talk a little bit about, the payment of rent once the moratorium is lifted, what are tenants going to be facing in terms of paying back the rent that they haven't been able to pay?
Great question. I should have included this in my presentation. Okay, so moratorium's lifted, you owe 6 months rent. Most people could not come up with 6 months rent. The landlord, if they file, hopefully you would negotiate an agreement before filing, but let's assume that doesn't happen. If they file, the court can require that you enter into a legitimate repayment plan. Now, it has to be reasonable. If you owe $1,000, you can't pay that off in 10 years. But those are all court decisions. But you do have the opportunity to litigate that in court. It would be unusual for most people to be able to pay all their rent owed at the end of at the expiration of the moratorium.
And sorry, maybe you just said this, but it's my understanding that landlords have to offer a reasonable repayment plan. Is that true?
They don't have to offer, but you, as the tenant, can offer it. You can say, okay, I owe you $1,000. Can I pay $200 a month until it's paid off, or something like that? And here's my income that I anticipate getting, post-COVID. It's an equity in housing means what's fair to the litigants. So if you can show equitable grounds, an equitable basis for what you're suggesting, that the landlord is going to get paid, it's going to take some time, it's very likely a court's going to order that. So you're not without, if at the end of the moratorium you owe a bunch of money, that doesn't mean you're automatically evicted at all.
That's really, really helpful to know. And in terms of what is a reasonable payment plan, is that just going to be determined by the courts on a case-to-case basis?
Case-by-case basis. Yep.
Wow. So your pro bono legal services are going to be really needed when people...
Well, I don't want to be too serious about this, but I know how important housing is for people. And I know how devastating it is to lose housing. So we're, kind of eager to, if necessary, represent as many people as possible in court to mitigate the damages.
Absolutely. Okay, we've got one more question that just came in.
Sure.
If a tenant walks away when their moratorium protection expires, what is the landlord's recourse for getting that payment?
The recourse would be, you could still go to court, petition the court for possession, which wouldn't be much of an issue because the landlord, that tenant's already vacated. But the second part, the damages, the landlord could go back to court after possession and say, I'm owed $3,000 in rent, get a judgment, and if possible, they could pursue that judgment against the tenant. A judgment is an order by the court saying you owe X amount of dollars to the plaintiff.
Great. Well, this has been really informative, and I see some people are expressing appreciation in the chat. So thank you, Steve, so much for your time and expertise. And
well, thank you, Justine, and thank you, Shauna and Mary and Ariel and Lindsay. It's really cool to see this coming together, and any part that NJP can play is something I really like doing.
Great. We can wait a couple more minutes in case folks have other questions. Sure. And so, yes, so the phone numbers that we put up and the resources, those will connect you to the Clallam, Jefferson pro bono lawyers and the Northwest Justice Project, and then they can reach out to you as they're able to. And it's important to note that these are all volunteer attorneys who have their normal job duties, and so getting to offer these services is something they do on top of that. And so it's really, really wonderful that they offer those, but it can take a little bit of time to hear back. And Steve, I don't know if you have any suggestions on, how folks should handle if they're waiting or if they're unable to get through.
Well, I think I do. For NJP, the first option is to call Clear. Clear is open 9:30, 12:30, Monday through Friday, but I certainly recognize it's hard to get through. It's a statewide intake, and it's hard to get through, and it can be very discouraging. I guess what I can do, I'm not sure if I should do it or not, but let me give my direct number, and if people want to call me directly, I think that'd be okay. Let me throw it out there. If I get swamped, I'll pull back, but it's probably important that they have some kind of access to me. My direct number is 1-206-707-0845. My name is Steve. And, you know, call me if you have any questions. And what Lindsay just put up, I can't emphasize enough how good the Washington Law Help website is. It covers almost all civil matters possible, but it's exceptionally good when it comes to housing. So I would encourage anybody who has more specific questions, go there first. And then if you have questions, contact either me or, VLP or Housing Solutions or anybody to more fully expand on what you think the law says.
That's really helpful. And Steve, would you mind going over those phone numbers for the mortgage and the rent assistance again?
Sure.
And I will put these in the chat box. So if you aren't able to write them down, hopefully I'll get them in time and you can look at the chat panel.
For mortgage, it's 1-877-746-4334. And for the emergency rental assistance, in addition to OLLICAP and all the local agencies, it's the 211 or the 211 website. And you'll be looking for emergency rental assistance.
Can you say a little bit more about what the 211 website is?
I think that's like the civil 911 website. I think it's just a listing of social service agencies.
Great. And you can also call your federal senators and tell them to pass the $1 billion in federal relief in the HEROES Act.
Absolutely, but we're unprohibited from political action.
Great. We've got one more question.
Sure.
If someone isn't facing eviction but owes money for past rent, can they get help working out how that past rent is paid with you if a landlord is asking for that immediately?
Well, two things. If you owe past rent but you're current on your current rent, then you're not subject to eviction because the back rent owed is a debt owed. It would not be unusual for me to take that kind of a case and try to negotiate with the landlord to avoid further litigation.
Great. And just a note about Housing Solutions Network, we are not a direct service provider, but we do really want to help people to resources, and we would love to see more resources for tenants in Jefferson County. So if you're a tenant and you want to get connected to us, we don't offer legal services or housing services directly, but we are a network and a connecting point to both service providers and to other people who are organizing around affordable housing issues in Jefferson County. So reach out to housingsolutionsnetwork.org if you want to get involved in that way. And I think that is a wrap for today. We don't have any other questions. Steve, I really want to thank you so much for your time. And Shauna with the Clallam Jefferson County Pro Bono lawyers who put all of this together and connected all of the pieces for us. And Steve for sharing your expertise today. And there's going to be a presentation for Clallam County tenants, the same presentation on September 19th. So if you know somebody who would really like to attend this full presentation and not just watch the recording, my understanding is that they could also attend the one that's directed at Clallam County folks, since a lot of the information will be the same. Since we're still on here, it looks like there's one more question that's not quite clear, but it's saying CLE credit for lawyers? Question mark. Do you know?
No. Continuing legal education, but no, we haven't applied for that.
I see. Okay. All right, so we'll leave the screen up so you can take down these numbers. And again, some volunteer attorneys are going to be available directly after this presentation. So if you call those numbers today, you might be able to get through to them. And there's actually a really important question that just came up. Are there Spanish-speaking legal advisors?
Yes, and the only thing I know about that is I know Clear, the NJP intake line absolutely has Spanish-speaking advocates.
Okay, I think we're going to wrap it up. So take down those phone numbers and feel free to reach out if you're in need of assistance, and really hope that you all got your questions answered today and that we can all keep folks in our community housed through this pandemic and beyond.
Thank you.
Thank you all so much for being here.